Welcome everyone to Coffee and Conversation. We're so happy to have Joanne DiPietro back today to talk about the importance of reviewing your documents every year. Just want to take a moment to remind everyone that this is being recorded by Walpole Media, and if you don't want your image displayed on the screen, you can turn off your video at this time. And I'm going to turn it over to Joanne. Thanks, Joanne.
Great. Thank you so much, Deb. Hello, everyone, and Happy New Year.
Thank you.
Happy New Year.
Thank you. So we have a clean slate, right? We're all starting from spot one, and we're going to have a great year this year. The good part is it's not pitch black at 4 o'clock anymore. So to me, that's helpful that I can go home and still have daylight after work. What's also helpful is that, we have vaccines coming, and I'm sure you're all up to date on that. So we have, we're checking off some of our New Year's resolutions here. And as we talk about every January, this is the best time to start looking at both your estate planning and then also your finances and your assets of what's going on. One of the things that you also have in the back of your head that you're going to have to do shortly is your own individual tax returns. You'll be filing that in April. So this is a great time for you to kind of grab your arms and take everything that's going on and start evaluating everything and looking at it individually to see if anything needs an update. As we talk about estate planning, it's very important for you to review your documents, but then also look at how old your documents are. One document in particular is very important that you look at how old it is, and that's your durable power of attorney. Your durable power of attorney allows your attorneys, in fact, to basically slip into your shoes and act on your behalf with a lot of different things, but most particularly financial things that are going on in your life. This is very important to have this durable power of attorney effective, because in the event you do not have one and you become incapacitated, you're unable to know exactly what's going on. Someone would not have an ability to speak on your behalf. And if someone can't speak on your behalf, then we will have to go to court and have a guardianship appointed. Okay, so as you can imagine, having a durable power of attorney versus a guardianship is more costly and time consuming than having a durable power of attorney. So that's one reason to, someone have a comment? No? Okay, because I'll keep going. You can interrupt me if you have questions, but please make sure if you have any questions that you reach out to us. So again, looking at your documents, the date that they were created is very important, okay? And when we're using a durable power of attorney for financial reasons, there's no written rule that they should be updated every 3 to 5 years, but it's more or less, if you don't update it, then there could be a presumption that if someone produces a durable power of attorney that's 15 years old, in my mind, I would say, maybe they drafted another one and we don't know where that one is. So as you can see, it becomes a little gray, and attorneys don't like gray. We want to make sure that we have the most effective and the latest dated document to utilize, okay? Now, in addition to looking at the date of your documents, it's very important that you look at the fiduciaries that you have appointed. What's a fiduciary? A fiduciary is a person that acts on your behalf. So for instance, your attorney in fact, under your durable power of attorney is the fiduciary that you have appointed. And remember that your fiduciary they have an obligation to the beneficiaries of the estate. So if it's a document like a durable power of attorney, they have an obligation to you as the attorney in fact to basically not abscond with your funds, okay? In the event it's a fiduciary appointed under a will or a trust, these are post-death documents, that fiduciary has an obligation to your beneficiaries to make sure that they are handling your funds and your assets in a reasonable manner, all right? So we can talk about the different documents that have a fiduciary appointed, but we can save that for another conversation if you'd like. But again, if you have any questions. But I like to use this opportunity to reiterate to you, again, you're getting your documents together for your income taxes. It's a great time to talk to your financial advisor. There have been some changes in the laws, most particularly with the Secure Act that came out in last year. And that has to do with your investments, okay? Because remember, your investments are also part of your estate plan. Your investments that you've created while you're alive more than likely have a beneficiary named. We need to make sure that that beneficiary is correct. So whether it's an IRA, an investment account, or even your life insurance policy, check to make sure that that beneficiary is who you want to be on that schedule of beneficial interest. Okay, so check that one off too. You want to make sure you take care of that. Now, going back to the investments, the Secure Act changed the way an IRA, which is your individual retirement account. If I have an individual account, an individual retirement account, someone is going to be the beneficiary, and that someone gets it upon my date of death. What the Secure Act did, it basically said the person that beneficiary that gets the funds has to use those funds within 10 years, okay? So if an exclusion is somebody under the age of 18, so let's just say my daughter's 19 years old, which will scare me because she's only 15 right now. But once she's 19 years old, and if she inherits that, she has to use those funds before she's at the age of 29, okay? So you can imagine a girl that young is not going to use a lot of those funds because she would more or less want to keep it for her own retirement, okay? So this is where I say to you, you want to use all of the professionals that you have. If you have an IRA account, check who the beneficiary is, talk to your financial advisor about the Secure Act and how that has been changed, okay? That's one thing that I want to bring to your attention. Now, the other thing that the Secure Act did, and many of you may already know this, it has to do with your required minimum distributions. The age went up. It was originally 70 and a half, it's now 72. Okay, so for you to take your required minimum distribution, it's that amount has changed. So if you have your financial planner created a plan for you to be receiving money at a certain age, at the age of 71, you're not getting your minimum distribution at the age of 71 anymore. Okay, so you need to keep mind of that. So what you can do is if you're younger than the minimum distribution amount, you can convert those funds over to a Roth, and that's within the Secure Act. You know, every time we hear that they make laws, there's always something that they give us an opportunity to take care of as well. So you just want to make sure that you make inquiry on that. Gifts. We talked about gifts in December. So the exclusion amount on gifting is your lifetime exclusion. If you give the $15,000 that we've discussed previously to a single person for over a 1 year period, that does not eat into your exclusion amount that you have, your lifetime exclusion. So gifting is a tool that is utilized to bring down your assets. Why do we want to bring down our assets? We want to bring down our assets generally for two reasons. One, to get below the threshold of estate tax, the Massachusetts estate tax threshold of $1 million. And possibly the other reason is if you're spending down to try to qualify for government support, which is also known as Mass Health Services. Both of those techniques for gifting are also subject to the 5-year look-back period. Okay, so you have to be mindful of that if you need to eventually apply for Mass Health Services, which means the government pays for your care at a nursing home, you do need to take in mind that any gifting that you do could make you ineligible for a certain period of time, okay? So make sure that you take care of that. Now, one of the other things that you can do for gifting is that you can gift to a grandchild or a grandniece or whoever it may be the $15,000 to put into a 529 college savings account. Okay, that's also another way that gifts can be utilized in that manner. Another great way to spend down on your estate, again, for threshold purposes for estate taxes or for qualification, is to to pay directly medical expenses and education expenses for someone. And that someone could be anyone. It could be your children, it could be a niece, a nephew, it could be your grandchildren. That's another way to bring down your estate. And, you know, I continue to reiterate, these are just things that we want to look at, that when you have your goals set up, every year, look at those goals again and make sure everything is still functioning in the way that you want it to. Now, one of the other things that we continuously talk about are trusts. We create trusts in order to accomplish different things. A revocable trust, you still have dominion and control over all the assets that are placed into the trust, okay? You think of a trust has two layers to it. There's the legal title, there's the beneficial title. You're still the beneficiary of that trust. You have the right to use everything that's within that trust. So it's really still yours, okay, when we talk about estate tax purposes and mass health services. How do we use trust in a different manner? Is an irrevocable trust. So an irrevocable trust, you lose dominion and control over those assets, okay? So we talk about this, on a yearly basis. Is it time now? Is it time now to create an irrevocable trust? Is it time that within your life that you can actually lose dominion and control over those assets, and it won't change the way that you're living? It won't change how much you need to live on an annual basis, okay? And again, this is going to looking at everything that's going on in your life, medical, financial, your assets, to see if it's time to move to an irrevocable trust. Now, the fact pattern, your own fact pattern, is very important when we're making these decisions. Again, you can use it to minimize your estate taxes. Perhaps you create an irrevocable trust and everything is put into this irrevocable trust for the benefit of your spouse. And since your spouse now has the dominion and control, what happens is who has access to it, you can actually benefit from it. Becoming eligible for those government programs, again, to plan for Medicaid or special needs trust, but then also protect your assets from creditors. So that's another way that we use irrevocable trusts. Now, remember, there's also negative things that come about by using the irrevocable trust. So again, your fact pattern is very important. All this information that we provide is as a courtesy, but I can't stress enough that it's very important that you speak with your own attorney or you speak with your financial advisor as to anything that you're doing. So let's go back to the fiduciary appointments. So it's important to look at who you have appointed within your estate plan as your fiduciaries. And there's things to think about. Did that fiduciary leave the state? Are they no longer living close to you? Do they not have access to email or, any other ways that we communicate right now? Are they older now? Maybe they're no longer interested in being a fiduciary under your state. Another reason to look at the fiduciary appointments is, has somebody passed? Have they passed on? Or perhaps they have become incapacitated themselves, which is fine if you have made your successor appointments. However, you should look at those successor appointments as well to see whether or not those people that you have chosen are the people that are most knowledgeable as to what you need. Most particularly, again, during your lifetime, we have the durable power of attorney, but also the healthcare proxy. Okay, it's very important that whoever you appoint as the agent under your healthcare proxy, that they have knowledge of any medical conditions that are going on for you right now, okay? again, just to continue to reiterate that it's important for you to review your estate plan, your finances, and your assets on a yearly basis as a quick check. And a lot of that is done while you're getting ready to prepare for your own individual income taxes. But then also it's important to look at your estate planning documents in case there have been any tax changes or anything in your life too. My clients will say, when do I need to see you? I usually say the good and the bad. You win the lottery, you file bankruptcy, somebody's born, somebody passes on. You know, when there's life events, you want to pull out those documents and check them out to make sure that they're still going to fulfill the goals as to why you created those documents in the first place. Okay? Are there any questions? Yes. Gloria, you have to unmute yourself.
I just wanted to ask, I went to the bank where I have my, it's a retirement IRA, whatever, and to take my 10% out. And she said that they had just changed the thing for this year because of COVID. And then you don't have to do it until next year.
Okay, yes, that is true. There are some rules that were implemented because of COVID. Most particularly, like even I have some clients that have called me about getting the real ID. That was originally supposed to, you had to have a real ID by October 2020, but they've extended that to October 2021. That is correct on the distributions as well. Yes.
Thank you.
But I don't know if there's an end date on it. So that would be a question for your financial advisor or your tax advisor.
Thank you.
You're welcome. Anything else? Hi, Linda. Linda, you have to unmute yourself.
Oh, there. Now can you hear me? I'm all
Yes, I
set.
can.
Okay. I might have missed it, but I know you were saying that every year we should review our documents and everything. But is there a record, or a recommendation, I should say, of when you should update them? How long can you let them go if things sort of remain the same, but what would be your recommendation is all?
So if your fiduciaries under any of your documents was to change, again, whether they themselves lost capacity or they moved out of the state, or if they have passed on, then you want to make sure that your successor appointment is correct, that you're still comfortable with the successor that you had appointed. But I do recommend that any durable powers of attorney are updated at least within a 5-year period.
Okay.
And then the healthcare proxy is more so, you know, if your own health conditions have changed, and let's say if there are any medical procedures that you do or don't want, if that has changed, you would also want those listed within your healthcare proxy.
Okay, thank you.
You're welcome.
Like Olga has a question. Olga, are you unmuted?
Yeah, I wasn't even sure if I'm in because my face is blank. So I don't know. I guess, yeah, about the Secure Act. I'm a little bit late on that, but oh, here's my face.
There you are.
Maybe it's better if I do.
No, leave it there.
About the Secure Act, I didn't really quite get that. Is this just happening, or?
It actually was passed last year. Again, it has to do with your, it has to primarily, there's a lot to it, as you can imagine. A new law is, you know, voluminous. But the biggest thing that I like to draw people's attention to is that IRAs have changed. When your IRA goes to your beneficiary after you have passed, there is now a law that they have to use those funds within a 10-year period. And again, that wasn't there before. Before it was called a stretch and they could use it for, you know, during their entire lifetime. So there's different ways that financial advisors are assisting people so that they can figure out a way to implement the best route for a beneficiary.
Okay, so what you're suggesting, it would be, for instance, you to come and you could talk explicitly to me about it?
Well, I would love to talk to you, Ogle, but I am not a financial advisor. So
Oh.
I would recommend that wherever your IRA is held, that you seek some financial advice from them as to what other financial vehicles you could use or products in order to accomplish what your goal was.
Okay. All right. All right. I was not aware of that, so I'm glad I tuned into the conversation. Okay,
I'm glad you have too. Well, the problem is there's so much that's thrown at us on a daily basis. It's hard to sift through what is important for, each individual person. And, that's why I love when Deb asks me to do these things, because I myself have to pay attention too. And so it's good for us to be able to, transfer this information to everyone out there as well.
Okay. Well, thank you very much.
You're welcome.
Joanne, if somebody had inherited or was the beneficiary of an IRA prior to the passing of the Secure Act, has anything changed for those funds that have already been received?
No, because that would already be in their names.
Okay.
So it would have transferred over. So this would be funds that were still in the decedent's name,
Mhm.
the person that created the IRA.
Okay, thank you.
You're welcome. Anything else?
So Joanne, I take it that they did that for tax purposes.
Do you mean the government passed the law for tax purposes?
Yes. Yeah, so that they'd have to disperse the money over the 10 years and then they'd be taxed on it. Is that the idea?
I don't know exactly. That is what I'm not a tax attorney or a tax advisor,
Okay.
but that is what I've read.
Yep.
Usually when the government passes a law, it benefits them more than us.
Yep.
So I would take that presumption as well. And you're correct.
Yes. Okay. Going to get their money one way or the other.
Well, and that's always part of our conversation too, Laurel, is, you pay taxes when you're alive, you pay income taxes, and then upon your death, your estate has to pay estate taxes, both on the federal and the state level. So,
Yep.
and again, all of these facts are particular to your own, your own set of facts with your assets, but, just to become aware that these things are out there, and then you can investigate on your own as to what works best for you.
Yeah. Just the RMD is enough that you have to, you're mandated to take it, even though you don't need it, so that they can collect taxes on it. I'm like, all those years of saving, and now you still got to pay the tax. So it's like, whatever.
Yeah,
It's what it is.
It's just delayed. I know.
Yep.
I have a question.
Yes, Irene.
When you designate power of attorney, for your health and everything, I have everything under one name. Now,
Okay.
I was told I should distribute it, but indirectly I can't. Because
Okay, so you mean, Irene, you're using one person as your fiduciary for all of those roles?
yes.
Okay, so I don't think it's bad that you have one person, because that person most likely knows the most about you, correct?
Yes, she's right next door. I'm
Okay.
in an in-law apartment, but I have her for everything. But I
Okay.
have a son in Georgia. I have another son in the western part of Massachusetts. So she's the closest one.
Right. So the only thing that I can think of that someone may have said to you not to have the same person on everything is for checks and balance. There is case law, which is not statutory law. Usually what happens, there's case law that goes through the courts. Once the judges seem to be repeating the same things over and over again, which they're starting to with respect to having your personal representative and the trustee of your trust the same person, then there's no checks and balance there. The judges are liking if you have a personal representative and then co-trustees under your trust. So that's the only thing I can think of that perhaps someone told you not to have the same person, just so there is a checks and balance to make sure that your fiduciary is, adhering to their obligation.
Okay, and my husband passed away
Uh-huh.
and he had IRAs.
Yes.
But the way I understand it, or the way I see it, he never put me down as a beneficiary. So when he passed, the lawyer said it was no problem, that it automatically goes to me.
Okay, so we're traveling two roads right now. If you were not named under your husband's IRA as beneficiary, then that IRA asset became a probate asset because it was in his name individually and had nowhere to go upon his date of death. But did your husband have a will?
Yes,
Okay, so within his will, he left everything to you, correct?
yes,
So
yes.
it flowed to, one of his goals was to make sure everything went to you upon his date of death, and it went there anyway.
Oh,
Correct.
okay, because we had the same lawyer.
Okay, and so you just had to open a probate for your husband at the probate court, correct?
I think we did it, my daughter did it,
Okay, yep.
okay?
And then it traveled through probate, and then that's how it got to you.
Right. Now,
Yep.
we have a revocable will.
Okay, so when you talk about revocable, it's a trust that you're speaking of, correct?
No, I was just wondering if something changes and you want to change something in the will, don't you have to have everybody's consent that's named in the will?
No, you are in control of your own will. And if you want to amend your will, obviously before your date of death, and you have the capacity to sign it, you can change your will by executing what's called a codicil.
Oh, okay.
So let's say you had Deb appointed as personal representative of your estate, and you said, nope, you know what, I'm going to put Joanne on there instead. We would create a codicil to change your personal representative. Okay,
Oh, okay.
you can change your will by way of a codicil. If you were to change your trust, it would be by way of an amendment.
Okay. Thank you.
You're welcome. Anyone else?
Mm,
I have a question.
Yes.
I'm wondering if you do change your will, an attorney told me every time you change your will or when you make a will, it has to be notarized. It can't be just like that he makes out the will, he gives it to me to sign. It has to be notarized. Is that true?
So the statutory law is actually that it has to be witnessed. So it has
Witnessed.
yes, it has to be witnessed by two people. But us attorneys, we like to have everything notarized because then we know it's everyone's free act and deed, willingly and voluntarily. They had capacity upstairs, and also that they're over the age of 18. And the two witnesses in the notary, they usually land on a document called a self-proving affidavit. So when your will goes to the probate court to be probated, we know that those witnesses can attest that that person that signed it did it voluntarily and that they knew what they were doing. So that is correct what that attorney told you.
Okay, so in other words, if somebody had made out a will, just themselves, that wouldn't really hold up then, in other words.
Let's put it this way. It would hold up until it doesn't. It would hold up until
Okay.
someone said that wasn't their will, or they didn't know what they were doing, or there was fraud, or, it could possibly have been, someone signed their name. It's best
Right.
to have it done with the formal manners if you want to submit it to court.
Okay.
That's a good question because it leads up to something I've been thinking of. We had to change our whole will because of an incident.
Yes.
And my husband and I changed it. But because of my husband having early signs of dementia, I mean, he was still with it, they asked him a million questions before the will went through.
Show that he had periods of lucidity. Yeah, that's correct. Yep.
So, they asked him the day and the time and
Yes.
when he was born and all these questions, and they certified that he was a free mind.
Yes.
So if that is to be contested because of the incident, it'll hold up.
The person that is contesting it they have the burden to prove that your husband did not have capacity.
Okay.
That's basically, if they're the ones contesting, it's on them to prove that he didn't have that capacity. And that's why we have two witnesses. Because if that ever went to court, and which is basically litigation, those two witnesses would be called in on the stand and they would be asked questions before the judge to state that your husband had capacity when he signed his will.
Okay.
Yep.
Thank you.
And that's why formalities are important. You're very welcome. A lot of my clients will put stickies on the bottom of their personal possessions to state who they want those to go to. And 99.9% of the time, that's what happens. But, I always remind everyone that we are human, and when someone dies, it's a life event, and it can be hurtful. It hurts us. But, we need to make sure that everything's black and white in writing, because when we're human beings and our characteristics rise up, whether it's, a little resentment because my brother was treated better than I was, or whatever it might be. So it's always important to have everything in black and white in writing and using the formalities that go along with it.
Thank you so much.
Oh, you're welcome.
Hello. I just want to make a remark that was mentioned earlier about the RMD.
Yes.
Probably not your expertise, but I was told that under the new CARE Act, you did not have to take out your RMD this year. So anyway, that's what the financial advisors are advising, which gives you another whole year of full growth without taking any of that RMD out.
Yes, you are correct. And someone had brought that up because of COVID and the CARES Act. That is correct. But like I said, I don't know exactly when that expires. I don't know if it's next year or the year after or whatever it may be, but you are correct. Thank you for that comment. I appreciate it.
Any other questions for Joanne?
No?
No.
One last question I had. I think it is good that everything's in black and white, because in other words, if anybody said, oh, she told me she was going to leave me this, and it was an oral agreement between the two of us, whether it was between mother and daughter, or, for something that the other two weren't going to get, or whatever it is, she really doesn't have any real proof of that once the person's dead, right? I mean, she can say, my mother told me that I was going to get that, but unless it was actually in writing, the other, child might dispute that and say, I don't believe what you're saying, right? So it wouldn't really hold up, would it?
No, you're absolutely correct. And, then it goes down to, well, was it a flower pot that was bought in 1978, or was it a 3-carat diamond ring?
Right.
There's going to be a lot of interest in that 3-carat diamond ring.
Right, exactly.
Yeah, so that's usually personal, tangible property. Tangible property is everything you can see, feel, and touch, including jewelry, coin collections, things like that. It's important to list your personal, tangible items on a memorandum of intention to make sure that, again, with the formalities of notarization, and that it's incorporated by reference within your will, just so that it's out there in black and white as to who things are going to. You're absolutely correct.
Thank you.
You're welcome.
That brings up another question I have. I have designated one person to dispense of my personal possessions at her will.
Yes. And
Is
people
that-
can do that. Yes.
Is that going to create a problem? You know, I mean, the other kids will say, oh, I wanted that. You know what I mean?
Yeah, well, sometimes that's where negotiations come in, you know, and people will trade, whatever it might be. But, you know, hopefully they'll respect your decision that you left it in the hands of your daughter to distribute. You know, and that's what we want people to do.
You know, it's tough getting old and having to think of all those things.
Well, that's why we're here to help you, Irene. You know, I'm probably making you tired with everything I'm making you think about right now, but that's okay. You know,
No, it's clearing up things because
perfect.
it's
That's
so much.
exactly. Yep.
I
And
see
it can
that.
be confusing.
Sorry, Olga has another question, I believe.
Yeah,
Yeah.
thank you. I don't know, Joanne, if this is the appropriate question to ask, but how do you feel about an irrevocable trust? Some say, yes, go for it. The others say, think twice about it. It's not a good idea. So I am like juggling balls.
Yes, so that's a longer conversation, Olga, that you need to have with your attorney, because your particular circumstances and your particular goals will decide whether or not an irrevocable trust is good for you. That's one of those things that, you know, I can absolutely 100% state that you need a healthcare proxy, but an irrevocable trust is dependent upon what your goals are and your assets and what you're trying to accomplish. One of the hardest things about estate planning is that we don't have a crystal ball. We don't know what's going to happen in 5 years, 10 years from now. So that's one of the conversations that I have with a client when they move usually their home into an irrevocable trust. And, you know, I have to tell them the pros and cons of doing it. And then it's up to them to decide whether or not it's a good fit for them. So,
I heard stories about that. I have the whole in a irrevocable trust.
yeah, it can be good when you're trying to accomplish things and all of your fact pattern fits into that mold. But if it's not something that will work for you for whatever reason it might be, then I would suggest not to do it. But again, it depends on your own fact pattern.
Okay, thank you.
You're welcome. Sorry I couldn't give you an answer, but it really requires more.
Or okay, thank you.
Thank you so much, Joanne. You've been so helpful.